This hopefully reasonably short PowerPoint is about the free exercise clause. So there are two religious liberties clauses in the First Amendment to the United States Constitution. The first is the Establishment Clause, which I've done a separate PowerPoint for, and the second is the Free Exercise Clause. And essentially, the Free Exercise Clause is exactly what it sounds like. It protects your right to practice your religion or not practice a religion if that is your choice. And it's where we find the Constitution expressing support for religious diversity and religious tolerance. And um, it might seem absolute, it might seem pretty obvious that the free exercise clause means that you get to do whatever you want as long as it is in furtherance of your religious beliefs, but it's a little bit more complicated than that. So, for example, we don't allow religious practices that result in harm to other people. So, for example, we don't allow the First Amendment free exercise clause would not require the government to allow religious organizations to engage in ritual human sacrifice. Um, Fortunately, those kinds of issues don't come before the court on a very regular basis, but lots of other government policies can come into conflict with people's religious exercise. Most recently, the debates have centered around whether or not it is a violation of somebody's religious liberty to ask them to adhere to laws that apply to the general population, but that they would like to be excused from. So, for example, laws that prohibit discrimination on the basis of sexual orientation or gender identity come into conflict with some people's religious beliefs about homosexuality or about gender identity. And so these competing claims to be protected under the Constitution, whether it be under anti-discrimination laws or the 14th Amendment guarantee of equal protection of the law versus the free exercise clause of the Constitution, these are not easy questions for the court to answer. And we struggle as a country to determine when there are competing claims, which claims take precedence. And so these are important questions. And I just want to take a few minutes in this PowerPoint to talk a little bit about the free exercise clause and the various issues that have come before the court, and in general, how the court has approached the free exercise clause. And it's actually really interesting because we started out with going down one path of interpretation of the free exercise clause, and then the court kind of did a U-turn and suggested that the free exercise clause should be interpreted in a different way. And now we're kind of U-turning again, maybe into the other direction. So it's actually a really interesting area of law if you're interested in that sort of aspect of civil liberties. The two competing approaches to the free exercise clause are the approach that's generally referred to as accommodation. And essentially, what the accommodation approach suggests is that when there is a law that applies to the general population, but that law goes against a, a religious practice or a group's religious beliefs, then the law might have to accommodate those religious practices and not require that they follow the law. So there are lots of examples of this, and I'll give you the two classic examples that pretty much any introduction to American government class is going to ask you to learn. They come from the 1960s and the early 1970s. The first case is called Sherbert versus Verner, and the second is called Wisconsin versus Yoder. And Sherbert versus Verner is one of the first cases that came before the court that really looks at this question of under what conditions is the government required to accommodate people's religious practices and allow them to either not follow a law or to have a law not apply to them. In this case, in Sherbert versus Werner, the question was whether or not somebody who was fired from their job could nonetheless get unemployment benefits if they were fired from their job for reasons that were related to their religious beliefs. So there was a company in this state that decided to go to 7 day a week or 6 day a week production. And Sherbert was a Seventh day Adventist, and Seventh day Adventists practice their Sabbath on Saturdays. And that hadn't been a problem for her because she worked Monday through Friday and it was never an issue that she would have to work on her Sabbath. But part of Seventh day Adventist is to take very literally the Sabbath as a day of rest and a day where you don't work. And so she refused to work on Saturday and she lost her job. As a result, the boss said, hey, nobody wants to work on Saturday, but everybody's got to work because this is the new rule for our company. And so she filed a lawsuit arguing that the company had violated her free exercise rights by not accommodating her religious beliefs. And as a result, she lost her job and was then denied a government benefit that she claimed she should have gotten. Because usually if you get fired for cause, like you won't do your job, you don't get unemployment benefits. You get unemployment benefits if you lose your job through no fault of your own. So she was arguing that even though she technically lost her job because she refused to work on Saturday, the reason she refused to work on Saturday was because of her religion. And the Supreme Court agreed with her in 1963, in this case, Sherbert versus Werner, which is a super, super important Supreme Court case that sort of establishes this notion that the free exercise clause requires government to respect people's religious practices. Now, there are a lot of ways that we accommodate religion in our policies. We don't go to school over Christmas. We have our spring break right around Easter. And a lot of mainstream Christian holidays or practices are accommodated in the law as a recognition of the fact that these practices are important to a lot of people. But not everybody follows those religions, and some people's religions require things that are not already accommodated in the law. So, for example, I sometimes have students come to me and say that their faith is, there are some holy days coming up in their faith, and they are required to turn off their electronic devices and not use electricity after sundown. And so could they please get an extension on an assignment that's due the next day or something? And I accommodate them because I recognize that people's religious practices are really important to them. I wouldn't have to accommodate somebody who says, hey, can I have an extra day to do an assignment because I want to go out partying with my friends, right? It's different when it's a religious practice because freedom of religion is protected in the Constitution. So the accommodation perspective suggests that you should sort of bend over backwards to recognize people's religious practices and the importance that those play in people's lives, and sort of cut people some slack. And Sherbert versus Werner reflects this. Probably the most famous accommodation case is a case called Wisconsin versus Yoder. And it's famous in part because it involves something that is a fundamental part of state government. And that's the state government's responsibility to ensure that children get an education. Some people would argue that public safety, police services and stuff, and education are pretty much the two really fundamental important things that state governments do. So education is a really important state function. And there's a recognition that states have a right to set standards for education. So this case involved the state of Wisconsin and a family called the Yoder family, this is Mr. Yoder, they're Amish. And it's part of the Amish religion that it's a very secluded religion. The people don't interact. People who are Amish don't use electricity. They don't drive cars for the most part. They have fairly limited interaction with the secular world outside of sort of businesses and making a living and that kind of stuff. They tend to be a sort of insular community. And one of the practices that is common in the Amish faith is to take their children out of school after 8th grade so that they can work in the family businesses and complete their religious training without influence from the secular world. That's part of their faith. It's been an established part of their faith. Well, the state of Wisconsin, at least in 1972, I'm not an expert on Wisconsin educational policy, but most states require that kids stay in school legally until they're at least 16 years old, and that's usually junior year in high school, at least, something like that. And the Yoder family, based on the decision in Sherbert versus Werner, asked for an accommodation to that general policy that applied to everybody. All kids going to school in Wisconsin were required to go to school until they're 16, and the Yoder family asked for an accommodation of that, saying it's part of our religious practice to take our kids out of school after 8th grade, which maybe they're 13 or 14 years old, and the state of Wisconsin denied them. They said, this is different from Sherbert versus Werner because the responsibility of the state to educate children is so great that it overrides your desire to take your kids out of school. And the Yoder family obviously filed a lawsuit, and in 1972 the Supreme Court sided with the Yoder family. And when the Supreme Court makes a decision that says the government is expected to accommodate people's religious practices to the greatest extent that they possibly can, it doesn't just apply to the Yoder family. It sends a message to government entities everywhere that, hey, look, you need to think about how you're implementing your policies and implement them in a way that accommodates people's religious practice. This is a really strong way of protecting, especially minority religions, many of whom have suffered from discrimination in the past. It's sometimes very easy, not necessarily in a mean-spirited way, but it's sometimes very easy to people who practice a majority religion to dismiss the importance of minority religious views. It's easy to say, well, that's not part of my religious belief, so it can't possibly be that important. But we have to recognize that to the people who practice those religious practices are very important. They might not be your beliefs, or they might not be my beliefs, but they're important to the people who believe them. And so the accommodation standard says, look, if we're going to truly be a country that celebrates religious diversity, then we have to celebrate religious diversity by allowing people to be exempt from policies that would require them to go against their religious beliefs. So for a long time in our history, this was the expected response of government, would be to accommodate. To 1990, in a case called Oregon versus Smith, where the Supreme Court pretty much did a complete turnaround. So Oregon versus Smith is a really important case because it establishes this notion of secular regulation. It's sometimes referred to as the secular regulation rule. And it involved this guy here in this picture. His name is Al Smith. He's a Native American. And he worked as a drug rehabilitation counselor in a drug rehabilitation clinic in Oregon. And part of his Native American religious practices included the ingestion, the smoking, I think they smoked peyote, of a hallucinogenic drug called peyote. Well, under Oregon law at the time, Oregon law has since been changed, but at the time, the use of peyote was prohibited under Oregon law. And lots of drugs are prohibited under Oregon law. You can't shoot heroin into your veins, etc. And Smith lost his job for workplace-related misconduct. He was fired from his job as a drug rehabilitation counselor for using an illegal drug. So he applied for unemployment, and the expectation was that he would get it because he was fired because his religious practice is what violated the law. He wasn't violating the law because he just wanted to get high. He was violating the law because his religion required it of him. But he lost. The state of Oregon won this case, and it sent shockwaves through religious communities throughout the whole country. There was a lot of outrage. What the court essentially said was, if the government's purpose is an important purpose, if the government has a good, legitimate reason for regulating behavior, they don't have to accommodate automatically. People can be required to abide by valid laws, even if their religion would require them to break those laws. In other words, the court suggested that religious adherence to somebody's religious practices is no longer going to have the sort of place of pride of place at this elevated place when it came to the enforcement of secular laws, laws that are that apply to everybody, that are generally applicable to everybody. If you can think about this from the perspective of not just minority religions, but Christian religions as well, a lot of religious leaders saw this Supreme Court case as a threat to religious liberty, as a signal that the court was going to allow the government to interfere with people's religious practices in a way that they did not like. So there was a lot of backlash against Oregon versus Smith, and a lot of laws got passed to try to overturn legislatively Oregon versus Smith. Some of them got struck down by the Supreme Court as unconstitutional. But one example of a law that was passed by Congress after the 1990 decision is a law called the Religious Land Use and Institutionalized Persons Act. It was established by Congress, I believe unanimously. I think this was a unanimous decision by Congress and signed into law by the president. And what it does is it specifically says that when it comes to federal land, and that would include and any government that gets money from the federal government, so any agency or department or program that gets money from the federal government has to go sort of back to this accommodation standard, right? Has to accommodate people's religious beliefs unless the government can demonstrate that their need to infringe on somebody's religious beliefs is compelling. It's the highest legal standard for the government to face. And one of the purposes for Congress passing this law was to nudge the country back into an accommodation perspective rather than this sort of secular regulation, lower standard. And what's happened as a result of this law and a couple of other laws that have been passed by the federal and by state governments is that courts are starting to recognize and move back toward this sort of accommodation standard because that's what the federal law now requires. It's a really interesting stuff that's going on here. And in some cases, that means people's religious practices get accommodated in ways that they might not have had to accommodate. The government might not have had to accommodate under the Oregon versus Smith standard. They're going sort of back to this Wisconsin versus Yoder, Sherbert versus Verner standard. I'll give you an example. There's a case from 2015 called Holt versus Hobbs. So Hobbs is the prison director. Holt was a Muslim prisoner who was in prison, and he asked the prison if he could have an accommodation for his religion to grow a beard, and it violated the general policy that the prison had for facial hair, because he wanted to grow it longer than the standard was allowed. So the standard was you couldn't have facial hair that was longer than 1/4 of an inch long. And the reason for that is they wanted to make sure that people couldn't hide any contraband in their beard. They wanted to ensure that if somebody escaped from prison, that they couldn't just shave their beard and then the prison picture wouldn't look like them when they tried to find them again. And they argued that they had already accommodated Holt in a number of ways. He was given prayer mats. He was given opportunities to pray several times a day. He was given food accommodations. He was not served pork. His dietary needs were accommodated, etc. And the prison argued that they had legitimate safety and security concerns about allowing him to grow his beard to 1/2 an inch rather than 1/4 of an inch. Holt and his lawyers used the Religious Land Use and Institutionalized Persons Act to argue that the government's interests were not strong enough to justify denying him his rights. They argued that you couldn't put anything in your beard if it was 1/2 an inch long that you couldn't put in your beard if it was 1/4 of an inch long. So they argued that that was an arbitrary distinction that didn't actually serve a public safety concern. They also argued that the prison itself made exceptions to the 1/4 inch beard restriction for prisoners who needed to grow their beards out for medical reasons, like they had a skin condition or something like that would be irritated by shaving. And so he said, if you're going to accommodate these people's medical conditions, why aren't you willing to accommodate our religious practices? And so this case went through the courts and it made it to the United States Supreme Court in 2015, and the Supreme Court sided with the prisoner. They said Congress clearly intended the federal law to protect religious liberty beyond what the Supreme Court says is required. And the Supreme Court said, well, if that's what you want, if that's what you want the federal law to be, we will abide by that. And so what we're seeing now are a lot more cases that are maybe moving back in the direction of accommodation than was suggested was required under Oregon versus Smith. And some people think this is a good thing. Some people think that this is a bad thing. But it just kind of goes to show you that although the law is relatively stable over time, things don't change, from year to year to year to year, back and forth, the law does evolve over time. And sometimes it evolves in one direction and then kind of starts moving back in the other direction, in part due to who's on the court. As the court has gotten more, as the court gets more conservative or more liberal, its interpretations sometimes change. So that's why it's always very exciting to talk about and think about the issues that come before the court having to do with civil liberties.